obviously, but at least we got the decanting bill out, so
We wouldn't want to limit people's ability to.
the good news for all of you is I don't have COVID. I was tested for that. Whatever I do have is not COVID.
Sorry you're feeling poorly.
Now it's up to my doctor at 2:45 to figure out what it is. Solve it without putting me under. So we're taking up an act relating to prohibiting. Oh, no, that's next week. Sorry.
I went into the wrong committee this morning, and then when I was like, why aren't they ready for me? It was only then that I knew what was in the wrong one.
6:55.
She's gonna be here at 9.
And at 9:15, we have somebody coming. I don't know why. Oh, somebody wanted another carve out. This is where the problem comes in. You do this, and then everybody wants a carve out to see the record.
And then eventually they're not really sealed at all. Because everybody can see it.
Nothing, you might just as well leave them. And I thought it was just, by the way, I thought it was just. Anyway, so, good morning, the Senate Judiciary. It's Friday, April 19th, 2024. We're taking up an act relating to qualifying offenses for sealing of criminal history records and access to those same records, and who should have access and who shouldn't. And I'm going to start out by saying I think it's all backwards. So we should start out with, at a certain point in time, you can get your record sealed if it's one of the qualifying offenses. Okay, follow me through this. So qualifying offenses, you can have it sealed. If it's a misdemeanor, X number of years after everything is completed, the restitution, all of your requirements. If it's a felony, after X number of years, all the requirements are met, you get it done. After it's sealed, the only way you can gain access is the same as the juvenile system and you have to have a purpose, and you go to the court. And each agency that has a record keeps a record that has the name, birth date, and docket number, or case number, depending on, I assume an adult would be docket number. And you go to court and you say, this is why I need to see these records. Now, it could be the individual who wants to see the records to confirm that he was abused by his foster parent, and that may be part of his trauma and wants to sue somebody. It could be anybody. So it could be you have to go to court. It has to be the interest of justice. I believe that's how the juvenile sealing works. So you upset this whole apple cart, because we're going to have, we've already got carve-outs from a number of agencies. The Secretary of State wants carve-outs. The law enforcement officer on the street wants carve-outs. So if you want to go, because of that, if you wanted to go to a longer period of time than 3 and 7, because you're doing this, we could entertain that too. But I'm saying, does this make sense to anybody?
Yes. No, yeah, I totally understand your proposal, and it is, it's straight up a policy decision of how you want to do it. I would say that the work really would need to be around identifying who, looking at who is asking for access now, and then figuring out what is the standard for each one, because it varies a little bit. Like if you look at the juvenile law, it'll say DCF can have it, for child protection purposes, and here law enforcement can have it there. So you'd want to go through and still identify those entities who you wanted to allow to be able to petition, and then think about what is the basis of their petition. But you could also, you could look at like what those purposes are in the current proposal from the House, and you could just incorporate those in, but just say, just like you had said, follow the model for the provision in Title 33, where they have to submit a motion to do it, and then the court would decide. And each agency would have its own index, like the way that they do with the sealed juvenile.
The Department of Corrections, for example, might have an index. But that would be sealed, and it only contains the case number and the date, or the case numbers, or maybe multiple case numbers. I mean, this, it seems like a simpler system.
It seems like a simpler system to me. For everyone, not just the people operating the system, but also the people accessing the system. I think trying to explain to someone the tiers of sealing on the ground might be really difficult.
Yeah, but the Board of Cosmetology has access to your sealed record.
Exactly. It's sealed, but not really.
So are we saying then that it's super sealing all around? Is that after a certain number of years?
Yeah.
Yeah.
I guess we could call it that. I wouldn't call it super sealing. I would call it the record is sealed and nobody has access unless they have good reason
And
that
affordable.
they can prove to the court that it's in the, I believe the juvenile is in the interest of justice. I believe that's the term. Am I correct, Michelle?
I'm sorry, for an
The
interest
judge makes the ruling based on the interest of justice.
in 33.
Yeah.
It's, it varies a little bit depending on the circumstances, but yes,
So,
yes. So I feel a little bit like the skunk at the party, but I'm just gonna say this, so don't get mad at me. I'm just gonna remind you that the last sealing bill that you sent to the governor, he vetoed because law enforcement didn't have unfettered access. So I'm just putting that out there.
I do recall.
And you can obviously still
Well,
proceed with whatever policy you want.
I am not going to get into a kicking contest with the governor, but I think he and I agree on an awful lot of things. I said that to begin with. But this is one where I'm in a disagreement with him in terms of the value of sealing records for individuals. To me, this is the most important reform we can do in the criminal justice system, to make people who have a criminal record, give them the ability to move on with their lives. They've proven for a period of time that they're able to stay within the confines of the law. They've served their debt to society, as it were, whether it's jail time or whatever the requirements were. And now it's time to move on, and all studies indicate they're no more likely, and in some cases less likely, to commit a new crime than anyone else. But they still have the collateral consequences hanging around their neck. So I guess I would take the chance, and if we were successful in getting this through the legislature and getting it to the governor's desk, I would ask that we have it, and he vetoes it. I'd certainly talk to the administration, but if he vetoes it, and then we have a veto. I'm prepared on this one because I really believe in my 32 years here, we've done a lot of criminal justice reform efforts. And perhaps the most important one is this idea of expungement. And, we did it with deferred. We developed a youthful offender system, which is basically a deferred sentence, so that young people could take advantage of the opportunity to turn their lives around. All of those things, and I realize there's been this individual case that's got screwed up. But if you look at the 99% or 98% of those cases, they've successfully gone on to live their lives without being criminally justice involved, and that was the goal. So I'm gonna say that, in my opinion, this is an important part of that reform effort that I've been going through since at least the Douglas administration, when we started Justice Reinvestment too. And at the same time, we did some good bills. I mean, the sex offender laws in Vermont, if you remember what they were, you, Michelle, were the draftsperson. If you remember what the sex offender laws were like in Vermont before the Michael Jakes case and what they're like today, it's a totally different world. And so it's, while we've done some reforms, we've also done some pretty hard things, and we're doing them. We did them last year with S4 to respond to the activity we were seeing. We did it this year with S58 and S195. So I think our record in this committee of being responsive to criminal justice trends has been positive. But if we're gonna, in my view, we need to take a chance once in a while. I understand for Senator Norris, this may be a difficult leap, but I'm just saying, if we have to, we have to. I don't know what the House will do in reaction to it, but otherwise, I don't want to send the bill out. I don't want to send out something that is so slipshod that doesn't really seal the record. I mean, so.
Would you like to look at the exceptions to the sealing portion in the House version to kind of have you thinking about who you want to be able to petition, like as a starting point?
Yeah, what would be their basis for petitioning?
Well, I think it depends on, you have to think about each particular entity and what is the purpose. So like if.
So Dick Sears has a record. The record is sealed. Everybody's agreed.
Mm-hmm.
And it was a felony, and it's been 15 years. Let's just say, I'm just using that for example, 15 years. It's a felony. Why would the Board of Cosmetology have any reason to look at my record?
I would not be the right person to ask.
Well, I mean, why would they? That's,
Right.
I guess, my question. So on what basis would they look for my record? There would have to be some kind of a nexus between the crime. If it was the Board of Pharmacology, maybe. But how would they know? I mean, can they search everybody's record to find that one person who's applying to be a pharmacist? That's, I guess, my question.
So, you haven't
Yeah,
heard
well,
from
maybe we should
OPR
hear-
yet. Would you like?
Maybe we could hear from
Yeah,
you
okay.
right now. You've heard my opening remarks about changing the scope of the bill to a different method than super seal, so-called super seal. Maybe they'll call it super sealing on steroids, but
Hello, my name's Lauren Lehman. I'm the General Counsel for the Office of Professional Regulations. So I'm here to talk specifically about that exemption that you were just discussing.
okay.
And I would like to start to say at the point of, we completely agree with the committee. We'd like to have the exemption removed. And I'll walk through why that is for exactly the point you just spoke to. I think we do want to make sure, and this committee has a lot of history, a lot of background. We want to make sure that the implications of sealing for professional licensing are understood, because this is a policy choice. So as long as everybody understands the context and the ramifications, you know, we defer to your choice on that. So I'll start with kind of some background. We license 51 professions, from barbers and cosmetologists to pharmacists to motor vehicle racing to home contractors. I said I'd attach a list to my testimony, which I filed, and I forgot to do so, but I can submit that to Ben later.
Yep.
So currently, our process is for the majority of our professions, we simply ask in the application, have you been convicted of a crime? And if the answer is yes, we ask for the court records and a personal statement. If then we do a process of looking for the nexus, looking for mitigating circumstances, looking for time, and if it comes to we think that a nexus is close, we would do what's called a preliminary denial process, where the person has full due process rights to challenge that determination, appeal internally, and then appeal to the Supreme Court. If the person answers no, that's it, we're done. We don't check sealed records now. We don't look to sealed records or anything. For a small portion of our professions, we do FBI criminal background checks, and that's usually because we're in an interstate compact or that's regulated under federal law. And when those come up, again, there's a yes, we do our preliminary denial process. If it's a no, that's it. So to have, we had to have a lot of really strong internal discussions and thoughtful internal discussions after the House process to really understand what our goals would be here. And I think we all are in agreement that we don't want to start a process where we're looking for sealed records, where we're looking for that criminal history. We want to rely on our existing system, which is to ask if something's sealed, the applicant can say no. If something's sealed, the FBI won't show up on an FBI report. And that's been a determination of the courts that should be sealed. So OPR relies on that determination in making our licensing decisions. We don't want to change that process such that now we're going back in to determine whether a sealed record should be sealed for licensing purposes. We do want to make sure that folks understand what that means, because H655 does greatly expand the number of crimes that are allowed to be sealed. We regulate homes of contractors. Home contract fraud can be sealed after 7 years. When that person applies 7 years later for a home contracting license, we're granting them that license. We're granting them a right that a normal citizen does not have, and that the public trusts in that person because of that license. The H65 crimes now include all forms of embezzlement. That person, 7 years later, if it's a misdemeanor, can get an accountancy license. The public will never know they've embezzled before. Home contractor fraud, the public will never know that person has engaged in home contracting fraud before. Pharmacists, the public will never know that individual has diverted medications before engaged in prescription fraud with regulated drugs. So again, we fully defer to this committee and the General Assembly to make the determination that that's the policy choice that you want to make. Just want to make sure that that's understood, that we will not have that information. We will defer to the court. The petitioning process might be helpful in that, where a court decides we're not going to seal this record because of that potential. I don't know how many resources the courts will have and the state's attorneys will have, whether that potential for future licensing would be the reason to not seal a record. I'm not sure that there would be enough resources to even bring that consideration to the court when petitioning for sealing of a record.
Well,
but there is that kind of.
Yeah, I guess I would respond that state's attorneys may be, in certain crimes, may be more reluctant to grant a sealing motion.
Right.
For example, home improvement fraud, given the level of, or for a pharmacist or somebody like that, or embezzlement is such a wide variety of things. Maybe the person, I had a relative who was stupid enough to work for the United States Postal Service and steal money that people were handing in for stamps. He didn't get much, but he got a sentence. And that was embezzlement. But it was a minor amount, but because you were working for the United States government, you ended up serving some time. And I don't know that he ever would even apply to get sealed, but I'm sure he would have a difficult time getting it sealed to begin with.
Yeah, and I think that's a very good bulwark. I think we have to.
I mean, if the state's attorney had to find, I mean, if we don't go to automatic sealing, then the state's attorney has a role, or the attorney general, depending upon the case, in determining whether whether they want to argue against sealing somebody's record.
Right. I
And
think,
that to me is the, if we have to make that clearer in the bill, I think it's fairly clear, but that's the backstop to me.
I think the concern we'd have is the number. We heard BCIC testify, they went from 2,200 sealing a year to 22,000. And I don't know if the essays,
Now, a lot of that, I believe, was marijuana.
yeah. So, and then, the essays, there's many considerations. So your relative, he would want that cleared for really good reasons, for all the reasons we seal, and has no desire to ever be an accountant.
Right.
So should he be denied a sealed record for all those other reasons, simply because there's some concern he may apply to be an accountant one day? So just some thoughts on that, and we'll continue to do our job, and to, we are so supportive. We have a second chance determination where we will review a criminal conviction before somebody even undertakes schooling, so they don't, they know kind of their pathway. We do that full preliminary denial process and analysis for every single time somebody says they've committed a crime. It's very rare that we preliminary deny based on conduct. It's usually somebody who lied on their application. But if it's a criminal history, it's got to be really tightly tied to the profession. And even then, we frequently grant somebody a license with some short-term conditions to ensure, okay, you were engaged in diversion at some point, you can have your nursing license back. Let's do a year of supervision initially. So we really are very supportive of the goals.
One of the other things that I want to make clear is this would no way impact the child abuse or elder abuse registries.
Yeah.
So those would still be in effect for certain jobs. It doesn't seal or get rid of those records. You have to go through those two agencies to get that removed.
Yeah, and that's usually on the employer level that they're
Yeah,
obligated.
right. So, I mean, I know there's concern about those populations. There may be others who have, but I don't think there's any other abuse registries.
The only two where we're obligated to look at is we're not allowed to grant a license for to people who are delinquent in their tax or in their child support, and that wouldn't be sealed either.
No, those.
So those are the only two we're not allowed
Yeah,
to grant license for.
Other questions? Thank you very much. Been very helpful.
Thank you.
Tim, do you want to just
Sure.
what I just described? And I know I don't expect you to support it. That's fine. I'll just remind you that this committee has been very supportive of our state's attorneys on a number of occasions.
Yeah, I mean,
But I'm wondering how you react to that and to the idea that the state's attorney is really the person who, in 95, the AGO may have some cases, but the bulk of the cases, you can't go sealing without the state's attorney.
if there were a super sealing regime, my prediction, without conferring with any of them, having just heard it now in my live observation, Tim Leaders Dumont for the record, state's attorneys, would be that state's attorneys would be much, much more reluctant to stipulate to sealing if it meant that we had to get a court order every time we needed to use it for the limited criminal justice purposes. And the example would be a 3 a.m. domestic call where we can't have a court hearing to unseal it at 3 a.m. So we need to be able to access it to assess risk when we're asking for bail conditions or hold it out bail. And if we're having to do a super sealing, which would be new, and I would need to know like what that would actually look like, we don't have the time to have a court hearing at 3 a.m. in the morning about unsealing it in that matter. And I can't speak for the other, I'm just talking about criminal justice pieces, the other professional pieces I can't speak to, but that would be a concern for us. And the other one would be a person keeping an index. I would want time to figure out how that would be a huge shift from how we currently do it. How we currently do it, it might sound like the Stone Ages, but literally when we get a sealing order, I'm just using this as an example, we label it sealed, so we know. And we keep that court order that says it's sealed on top of the file, so that it's handled with care, so that we know it's not like something else. Expungement goes away, it's completely gone. And so if it were super sealed, we would have to, I'm just trying to conceptualize here in front of you all. It would be under here, we would have the name, and then to get back at the file, we would need to have a court hearing. And I don't know how we would actually implement that in our offices. And I'm just being completely honest, as the public records officer for all 14 offices, I don't know how we would implement super sealing with an index where we could get at the, who would hold the file while we didn't have access, would be my question. I'm just trying to figure it out in front of you all.
But
Sorry.
so my understanding of what Senator Sears is suggesting is what we already do for juveniles. So what is that process?
That process we would still have my understanding, what I'm talking about is the current, what I'm conceptualizing is current criminal case records. For the juvenile situations, as I've stated, and as former State's Attorney Kennedy said the other day, we're not often unsealing those, from my understanding. We are dealing with situations in the criminal justice system with adults that are happening in a very voluminous manner every single day. And I think in terms of how it goes with the juvenile side, I would want to talk with someone that's actually performed that. So, and I could get back to you on that. But in terms of an adult record, let's say that it was sealed, and after the time period, we want to get it unsealed. During that time period, the person might be detained, and for us to have a better understanding of risk, we would want to know, okay, was this person involved in prior domestic incidents in the past? And if we have to, and sorry, domestic would be a bad example. Prior assault of, let's say, simple assault.
You wouldn't get sealed for domestic.
So yeah, a better example would be
embezzlement.
Embezzlement, simple assault, disorderly conduct with fighting as a part of it, something like that. Another good example would be in the embezzlement context, this person's prior behavior with respect to that exact context. This person's now been accused of something, embezzlement 2.0. So I think just the choreography of how we would get it unsealed and the fluid nature of how we're actually dealing with these matters. I don't know how I would train our staff in that context. I would just need to think about it a lot more.
Well, I think with, the guard, it's a concept in my proposal, but we should look at all the crimes that are eligible for sealing or expungement. And remembering that we're going to keep deferred and youthful offender expunged. So those would be more serious crimes usually than what would be on that list. Senator,
just maybe a question more so for the committee, but when we're talking about collateral consequences, I get not being able to apply for a job, or having challenges with applying for loans for a house or school, but for this specific context that's being described, what is the rationale and the point behind prohibiting access to these records?
in my view, the record is sealed. It is as if it should be as if it has never happened. You're able to say with certainty that it's sealed, and you're getting a second chance. You're starting over, and why should that past record either be any factor in any decision that they make, unless there's some criminal justice reason for it. There's an uncomfortableness for me that somebody with a simple assault, barroom brawl, wants to get it expunged 10 years later is out on the driving erratically and taillights out, and the cop stops him and then is able to get the criminal history record of that bar and brawl that was sealed 10 years ago. I don't know what the purpose of that is.
I don't think that's something that would commonly happen. You know, it's not, I don't know if I characterized it incorrectly yesterday when I was talking about how record checks are performed on the side of the road on the rare occasion that they do happen, but you know, I mean more like the specific instance in which someone's been arrested for domestic assault. They have simple assault convictions on their record, and they're trying to make a determination as to whether or not that person should be held, or, you know, if they should be flash cited or cited, you know, weeks down the road. So I guess I'm not fully grasping why that information in that context should be prohibited. That's what I'm trying to figure out.
Okay.
Well, I would just throw in, again, if it was expunged, it would be not available to anybody. And to law enforcement, to judges, to DCF, nobody would have access to that. And so when we're sitting around the table thinking about what we do from here, for me, the driving point is what happens to people who right now would have the right to have it expunged. And if we change that to the point where it's going to be sealed in a way that will be permeable in any number of ways, obviously that's a horrible trade-off for them that we're making on their behalf. And so I take the point about public safety. There may be some situations where, you know, an old conviction might help law enforcement in the current instance. But I think those instances will be very rare, and what we'd have much more of is people looking at the old record and having it influence improperly decisions that are made about that person's life now. Decisions that could not be made if expungement remains in place. So I just want to make sure when I'm voting that I'm not giving away the security of expungement, which is that it's literally gone. And you are giving that up in a sense because sealing in any way means it's no longer literally gone. But the next best thing is having a judge control access.
One thing I might add is the other way that I could see it being cumbersome and potentially violative of constitutional principles would be when, and I'm just saying this because we have 25,000 cases and our department's at a crisis level of staffing, is when we are transferring discovery information to the defense. And sometimes that could be, as I stated, in more emergent situations, that can happen sometimes the same night or the next morning if it's like a flash cite or an emergency. Us having to unseal the record so that we can give the record back to the defendant and the defense attorney is something that we very seriously want to make sure we are always disclosing Brady Giglio material to the defendant. Here's your old record, including your sealed record. Now you can potentially impeach this officer who you've had interactions with 20 times. If we are not able to quickly give that information to the defense, sometimes within a matter of hours, that's the sort of cumbersome thing that I would want to think through about how we can make sure we can get material to the
But
defense.
if you keep expungement, there is no cumbersome.
That's and then we're having a sort of false reality where we're not allowed to do it. So it's that balance that you're talking about.
Yeah, to me, and I know you wanted to speak, the committee's choices are limited, really. We can rubber stamp the House bill with a few new exceptions. Other agencies have asked to have carve-outs similar to other agencies, which are legitimate. Since they're carving out one, why not carve out another? And I don't disagree with that. So we can pass the House bill with a couple of amendments. Governor's gonna veto that because the governor doesn't like to supersede, or the administration, I shouldn't say, I don't know if Bill Scott's even looked at the bill. The administration has voiced concern about the super sealing, so that would result in a veto. We can pass what I kind of proposed as a broad outline earlier, which is the sealing with the juvenile system, get the records with a little longer time before you can get your record sealed. The governor probably won't, the administration probably won't like that, the state attorneys, the law enforcement won't like that, they'll probably veto that, or we can do nothing and veto it ourselves.
Which is what we did last.
Seriously, I'm just darn serious, those were our choices. I can't, and I'm with Senator Baruch, and I think the majority of the committee, I can't in good conscience vote for the House bill. Or what you're all asking for. And that's my problem. So, I mean, I'm perfectly happy to, well, I can say perfectly happy because I wouldn't be happy. I'm never happy when we don't vote a bill out, but those are the realities that we have. Yes.
So sorry to interrupt, but I did have a chance to talk to AG Clark last night, and I sort of voiced a lot of your concerns and predicted a little bit of where we might go this morning. And I think her words are, don't throw out good in hopes of perfect, that this bill does achieve a lot. And yes, there are some things that need to be worked out, but it will help the vast majority of Vermonters.
But who does it help and who does it hurt? I mean, I understand if you're law enforcement or you're a prosecutor or you're the attorney general, it's more tools for you to not have expungement and to have access to all the sealed records. So that's a big win because you move back in time to before we rolled out expungement. But if you're the person who is hoping to have your record expunged and then to have it truly be expunged, that it doesn't exist and it can't be used, by having the Office of Professional Regulation deny you a license. The House bill, I think, it does have super sealing, but it's so porous that you can't really call it sealing if DCF, OPR, all law enforcement agencies everywhere in the state have access to your records. At that point, I don't know, it's affecting your ability to get a job, potentially, your ability to rent an apartment, your ability to not be prosecuted in light of past misdeeds. So I understand that the Attorney General might favor a version of the House bill, but for instance, legal aid does not, because they're thinking more primarily about the people who are meant to benefit from expungement.
Well, I think because most of the restrictions are out-facing, most Vermonters will benefit. And I think it's up to you, obviously, to hash out for how long or under what circumstances all these different agencies would get access. But, listening to the questions yesterday and prior days, police officers already have this information roadside if they want to use it.
Not if it's expunged.
Not if it's expunged.
That's the point.
But if it's sealed, but they prior to it being expunged, they have it. And it still goes into the calculation, and if it's misused or if it's used in a way that sort of bootstraps a lesser finding than what is needed, that gets sort of worked out in court.
But what we're talking about is getting rid of expungement. And under expungement, it is gone, and they don't have access. Nobody has access.
When I testified, I said we were in favor of keeping expungement, for instance, in deferreds, or when something is no longer criminal behavior. There may be other cutouts that I think haven't really been addressed.
I would say youthful offenders should remain expunged.
So, I think there is room for some things to still be expunged, but I think the other thing that Attorney General Clark would want to remind everybody is that this is sort of a process and there may be more steps later on, but this is a good bill for now.
So what if doesn't answer all the questions, but what if what is currently expungible remains expungible and we have a new set of criminal activity that is sealable?
I don't think that would get rid of the criticism of the dual track.
No, it wouldn't, but
Um,
the two that I'm most concerned about is deferreds and keeping them expungible and youthful offender and keeping it expungible, because youthful offender was always designed to be an opportunity to have it as if the crime never occurred, because you completed your sentence in the family system.
7 years, nice.
Yep.
My name is Lauren Lehman, I'm general counsel for OPR, and I don't think Senator Baruch and Ms. Kennedy were here for my testimony, but we were asking the committee to remove the exception for OPR, and I've put, in written testimony if you'd like to review it. So just as you consider the path forward, to know that we would like that exception removed.
I appreciate that, thank you.
Senator Bowles?
So I support Senator Sears, what you were saying about setting a time frame and fully sealing the record if we're gonna move away from expungement, because I actually think there is a fourth option that we didn't discuss, and that would be expanding expungement. And taking this bill and saying, actually, all this stuff is gonna be expunged, and we're not contemplating that. And I think it is overly complex to create a tiered system where we tell a layperson who doesn't understand the nuance of the law that your record is sealed, but not really until this point, and then it's more sealed. And I just don't think it really truly and fairly gives someone the second chance we are promising them
It's
through.
not a bad idea to look at what other crimes should be added to be expunged. The reason that I supported sealing was because I thought it was gonna be the same as expungement, and it's administratively simpler. Expungement is extremely time consuming and takes a lot of time because you gotta go expunge every record in the system. So the sealing is easier, and what Tim described, I'm not sure is as simple as it looks, because sealing, you're just saying these records are sealed, and you put a seal. Expungement, you gotta go search for them and get rid of them.
And the super sealing regime would be neither of those two things. It would be a new process that we'd have to
Yeah.
sort out.
And so, yeah, the super sealing is kind of I don't know where that term came from, but I best ask Michelle to outline what crimes are now new that would be sealed and not expunged.
I mean, I think it's not apples to apples, because if you look at like what you have as qualifying crimes under current law, there are different conditions for when things are expungible. And then there's the backup of if they don't think it should be expungible, it can be sealed. So like there can't be any intervening.
DUI is
offense.
sealable but not expungible.
Right, so it's just not, it's not like here's a list here and here's a list there. There's differences in terms of, one of them being that you have to have a totally clean record. And so, or else you wouldn't be eligible. It's a little hard for me to think about how to compare those two, because it's not just say, here's this offensive cruelty to animals and it's expungible here and now it would be sealable, because it's not the same under the two proposals.
So at least 3 of us hate super sealing, and as does the administration. So
we can agree on that with the
I'm not sure what I hate at this point.
All
I hate
of us
everything.
confused.
So the administration and the state attorneys and people don't like super sealing. The current system bogs us down. We have, I believe, 5 people in the court system doing expungements. That's all they do. They sit and expunge records administratively.
I don't, Mr. Chair,
Yeah.
if I think about that in isolation, I don't think that's a bad thing. That in our entire criminal justice system and penal system, that we have some people whose job it is to clear the record and help people get a start. 5 people is not a lot, if you think of it in those terms.
Well,
I mean, I think of it as part of the programming that we do to return people to normal life. So I get that, but I remember the testimony about the expungement
we'll see you
process.
this afternoon on your willingness to support the end of November something. After just here, administrative.
Well, you know I'm always with you.
I appreciate it.
So.
More or less joking.
Yeah, but I guess I remember the testimony about how laborious the physical process of expungement is. And I get that. And so I was initially a supporter of moving to a single track of sealing. We would get rid of even the term expungement and we would have sealing. But at that point, it seemed to me there was broader agreement that it was going to be very sealed. And over the iterations that we've had since then, it's gotten broader and broader and broader to the point where when we have the discussion, I feel like no one ever talks about the fact that we're moving away from complete expungement to a different system. So I would not be surprised if we don't find a compromise this time around, because I feel like the folks who are pushing to eliminate expungement over the last couple of years have gone broader and broader with what they want to replace it with. And I feel like that's why when this committee gets to it, we're like, what happened to the old idea of single track sealing with protections? But anyway.
Senator Sears, when did you, because my understanding is expungement is something you worked really hard on. When did that start?
I believe,
With Ben.
with Joe Benning.
Yeah.
So it's not,
You and I and Joe Benning.
No, it wasn't me. It was you and Joe, and I would say that was 2012.
Yeah, somewhere.
Very good.
so it's a system that is not incredibly old. And so I also wonder if as time goes on, those spikes in cases are actually going to level out, because more and more people will have, because you're getting an influx of people taking advantage of a somewhat new system. And if this 22,000 number is not going to stay that big, because over time, there just won't, do you know what I'm trying to say?
Sure.
Like it'll sort of level out. I also, I found the research study and I read it, and the uptake in expungement is incredibly low. The people who are eligible to have their records expunged that actually do is something like 5%. And so I imagine that as these laws sort of sit, that the workload will level out, because it's not going to be the same number of old things that are now expungible that weren't expungible prior to 2012. So I agree with you, Senator Baruch, that it is okay that we're asking people to do the work to put people's lives back on track. I would support looking at an expansion of the crimes that are expungible, but I can't support moving in a direction that is sort of a surface level ceiling.
Senator.
So I can get behind super sealing some circumstances, but I'm going to stick with my own viewpoint that I'm not trying to sound like a broken record, but again, I don't think that government should try covering, or should have the ability to cover its tracks after it's taken a course of action that curtails somebody's rights. I mean, when I was in the House, I was a huge supporter of expungement, and I don't know if maybe I read 1984 too soon before the session, but it just seems strange to me that, we have a stack of records, and after a certain point, we're completely deleting them and saying, just kidding, that never happened. We never arrested you. You never went to jail. We have no idea what you're talking about. It's strange to me, but on the same token, I want to do what we can to reduce collateral consequences and ideally eliminate them, after a certain point of time. So I guess what I'm trying to say is I can get behind super sealing.
But we're not erasing the record without the person asking us to. It's not as if the government is just saying, this record's gone and you don't know it's gone. It's the person petitioning to say, please erase this.
But if I might add, there is.
Senator Waters do.
Sorry, no, there are certain circumstances where things are expunged that are not involving a petition, one of which being a dismissal in a 5-count information, where we have to pretend that count 3 never happened via charging. And in that situation, it's a non-petitionable situation that we deal with every single day, and is one of the most labor-intensive parts of expungement, is where partial records are expunged. It's one of the pieces where, as you're saying, we're having to lie to people about what happened to them, and it also happens with acquittals. Very often in a trial, not all counts result in acquittal or guilty. There's guilty on counts 2 and 3, not guilty on count 1, and then we're having to erase count 1. And when the person comes back to us without a petition saying, I want my full record, including my not guilty on count 1, we have to say to them, what are you talking about?
But that's exactly my point. Even especially for the charges that are dismissed is, or somebody's found innocent and the charge itself is expunged and someone says, I was unlawfully arrested, law enforcement lied to me, the prosecutor, and so on and so forth. And then that record disappears. To me, it seems problematic.
Senator Westman often says from across the table from me in appropriations, the only reason we do studies is because we don't know what else to do.
Are you proposing a study?
I'm proposing study. I'm proposing that the Justice Oversight Committee look at other states and how they're sealing and how they provide access to various entities when a record is sealed. Because we're trying to invent a wheel here that's probably been invented in 10 other states. And I'd like to look at Justice Oversight, look at how other states do sealing and report back to the Judiciary committees and any of the corrections institutions, I suppose, on findings of other states and looking for ways to increase the number of offenses that would be sealed and how those sealed records are accessed by various groups in other states. We can't be the first to look at this.
I don't think we are.
So without that information, I don't think we can get that in the next 2 weeks.
I would support that.
That's the only thing I've heard today that I can get behind. And not kill the bill at the same time as to,
Yeah.
I feel rushed on this bill.
Yeah.
Trying to meet everybody's needs or requests and so on and so forth.
Yeah, I think it would be helpful to understand specifically how they deal with it. And particularly Pennsylvania, which what caught my eye was Pennsylvania is able to do 20, obviously they have a lot more people in Vermont, but they're able to do seal, 20,000 records in 20,000 seconds. I think your point is well taken. You're on the side of the road. You don't know who you're dealing with. There may be a law enforcement need.
In rare occasions,
Right? I still think, and this is another thing for the study, is what is the average time somebody applies after all the consequences have been completed? What's the average time somebody applies for expungement currently? Because I believe that it's only when you realize you've got a collateral consequence that you actually apply. And we're putting arbitrary dates, but it could be 20 years after the fact, because you suddenly realize you can't take your granddaughter on a field trip.
I mean, I think we could do a better job letting people know, like, I think, we could certainly, and I know the state's attorney.
Actually, I will say this for the state's attorneys and the attorney general's office, they've been pretty good
Yeah.
about holding these clinics. And I know a lot of people contacted me and said, hey, when's the clinic gonna be in Bennington County? Because, they heard about it in Rutland, and wanted to go to do one themselves. One of the other, a lot of people are confused by the fact they may not live in Bennington County anymore, but if the crime occurred in Bennington, or they may not have lived in Bennington County, but if the crime occurred in Bennington County, they have to go to Bennington County to get expunged. They can't go to wherever they're living.
Yeah, no, I certainly wasn't, I know the state's attorneys in many counties are doing excellent work in doing expungement clinics. I think my point was more to, the average time that it takes someone to apply, could shift and change depending on how much outreach there is. I think the important piece is what is the average amount of time at which their recidivism rate drops? Because that's, I think, the data we should be using for expungement should not be around how long does it take them to know they can expunge their record. It should be around how long does the record have a public safety implication that outweighs the collateral consequence.
That would be another thing to see is in other states, how long do they have to wait to be eligible to get a record sealed?
I think that's gonna be easier to get data on than the average time that people wait, because I don't know that
Yeah,
they'll track.
yeah, okay, well,
that.
Yeah.
forget that, that's anecdotal. But what is so for example, misdemeanors, what's the average length what's the length in the various states for misdemeanors and felonies? And they don't always have the same, some of them have class 2 felonies, class 3 felonies, and that gets confusing. New York confuses my constituents. Well, he was convicted of a class B felony. No, not in Vermont. Is that something that we can all agree on?
Yeah.
So we don't have to worry about car notes.
Not for a while.
Well, we can see what happens when we get to conference. Assuming there is one.
I suspect there might be.
Well, do you want to have a conference? Seems like if we send this over, it is what it is.
I don't think 2 weeks enough to do justice to this bill.
Yeah.
And I feel like, it's something I wanted to do, I really did. Sometimes lessons, right?
There is that rare moment.
There is that.
What is that they say about a broken clock? Even if it's right twice a day?
Richie's only right once a day.
Okay. So it's a clock that displays military time.
Super broken.
It's super broken.
So, we don't need any outside experts, we just need our own, justice oversight can do it, it's not gonna cost any money. And state's attorneys, and law enforcement can all give their voices.
And you can have this argument
We
again
can find
there.
out what other states do, and maybe some of the things that the state's attorneys and other groups are worried about are not valid, or maybe they are valid and they're taken care of in a different way. All right, well, good news. The rest of the agenda is, what do we have?
6:45.
Restorative justice.
Yeah, but we have a break scheduled.
We do. We're a little early. Do you want to do that now?
Sounds good.
Well, it would require Ben to
Exactly.
be here, and he may be.
Want me to text them?
I guess you could.
Check the schedule.
I need to leave here by 11:15 myself, so.
So we're not going to vote on
Quick,
it. Just go today.
quick minute or